It's not just about the currency, but fundamentally it's about wiring an internet for money.
What do you think will be the conclusion to the long-standing lawsuit between Ripple and the U.S. Securities and Exchange Commission? The legal battle between the fintech company and the SEC has been going on for 2 years now, and people are more than ready to see how it ends. But how and when will it actually end? At this point, everybody has their ears on the ground for any news from Judge Annalisa Torres of the Southern District of New York regarding the verdict of the long-standing lawsuit in the crypto space. As the ongoing lawsuit between the SEC and Ripple nears its end, several members of the XRP community have started predicting the outcome of the case. While some XRP enthusiasts believe an outright win is possible for Ripple, others think the blockchain company would lose its case against the Securities and Exchange Commission. In bringing the charges, the SEC has staked a claim to jurisdiction over cryptocurrency. At the center of the suit is the question over whether XRP, the crypto token on which Ripple's services are based, should be classified as a security, a tradable financial instrument like a bond or derivative, or something else entirely. If the court rules that XRP is a security, it would follow that almost all other crypto tokens are too, making them subject to the SEC's supervision. Not only would this impose burdensome registration and reporting requirements on crypto firms, but it also may have legal consequences for entities that have issued tokens or help people to trade them without SEC approval. Even large US-based exchanges may suddenly find themselves in the crosshairs. That, says defense lawyer John Deaton, who supplied expert testimony on the case on behalf of holders of XRP, would be very bad news for crypto businesses. In the absence of legislation that makes clear the classification of crypto assets in the U.S., the question of whether they should be treated as securities has to be assessed on a case-by-case basis, through the application of the Howey test. When the SEC charged Ripple and its executives, it declared that XRP met these criteria and that by raising funds through the sale of XRP, the company was in violation of federal securities law. Recently, an XRP fan with the username JV the Great led those who believe Ripple would lose, claiming in a Twitter thread that Ripple's XRP transactions are securities. He expressed confidence that Ripple would lose because the blockchain company did not put up a good argument against anything but the blue sky laws. Reacting to JV the Great's speculation, crypto law founder attorney John Deaton brought smiles to the face of XRP community members by explaining how Judge Annalisa Torres could give Ripple an outright win. In a Twitter thread, Deaton explained that while he does not believe Judge Torres agrees with the blue sky argument, he speculates that Ripple could win the SEC in the legal brawl that has lingered for more than 2 years. According to Deaton, Judge Torres could get around Ripple's XRP sales since the SEC did not apply the Howey test to every transaction. Instead, the regulator claimed that XRP itself is a security. Essentially, the SEC is applying the old but-for causation test in this case. The SEC essentially argues that for Ripple executives Jed, Chris, creating XRP, XRP wouldn't exist. But for Ripple helping create a secondary market for XRP, a secondary market wouldn't exist, said attorney Deaton. The SEC also argues that past and present XRP sales are securities. The regulator argues that countries outside of the US can only declare XRP as a currency due to Ripple's efforts. Deaton said, adding, Deaton asserted that Judge Torres could grant Ripple an outright win by rejecting the SEC's sweeping claims on the ground that the regulator did not prove a specific transaction. In other words, if El Salvador would have made XRP legal tender like it did with Bitcoin, the SEC is claiming it would all be due to Ripple's past, present, and future efforts. It is an extraordinarily all-encompassing theory, but that's not how securities laws get applied. The XRP community attorney slammed the SEC for being all over the place with identifying the common enterprise prong of the Howey test. At first, the SEC argued that Ripple was a common enterprise. The regulator later changed its stance on the matter after one of its experts claimed that the common enterprise was the entire XRP ecosystem, including XRP holders, exchanges, and independent developers. After a series of opposition from Ripple and the XRP community, the SEC abandoned the expert's testimony. Instead, the SEC argued XRP represents the common enterprise, while also arguing XRP represents all of the promises and efforts made by Ripple, said Deaton. He asserted that the SEC claims that XRP meets the second and third prongs of the Howey test through the argument. The SEC's claim about XRP is the reason why Deaton believes Judge Torres would not grant the regulator summary judgment in the manner they have requested. Meanwhile, Deaton predicted the possibility of Judge Torres denying both Ripple and the SEC's summary judgment motions, which could take the case to a jury. He added, "What some people have failed to consider is that Judge Torres could say denied to both summary judgment motions and it goes to a jury. Until we get to read all the Rule 56 facts and read all the underlying evidence relied upon, it's near impossible for me to predict anything more." The SEC's claims unconstitutionally expand Howey beyond recognition. Remember, the SEC admitted in its response to my writ of mandamus that it is the court that will decide whether the SEC's theory is valid. I'm confident Judge Torres rejects the SEC's wild, sweeping theory. It can be noted that in February, Ripple's chief legal officer, Stuart Alderati, said that he expected his company would, ultimately, be successful against the SEC's claim that its XRP cryptocurrency was a security. He said in a tweet, "The SEC has lost 4 of its last 5 cases in the Supreme Court thanks to the few that had the courage and resources to fight back against the SEC's bullying and clinging to stretched legal positions that were not faithful to the law." Alderati's comments came after bosses at the tech firm expressed their confidence that the case, which is currently before Judge Annalisa Torres of the United States Southern District Court of New York, would be decided relatively soon. Before that, Ripple CEO Brad Garlinghouse told CNBC, "We're optimistic that this will certainly be resolved in 2023 and maybe in the first half. So we'll see how it plays out from here, but I feel very good about where we are relative to the law and the facts." Adding that he expected the final ruling in the Ripple lawsuit to be handed out in the single-digit months. Garlinghouse said, "We have always said that we would love to settle, but it requires one very important thing, and that is that, on a go-forward basis, it's clear that XRP is not a security." The SEC and Gary Gensler have outwardly said he views almost all crypto as a security, and so that leaves very little space in the Venn diagram for settlement. Overall, the entire crypto community has been on edge awaiting the court ruling on the case due to the many implications of the decision on the entire crypto industry. The SEC has been pushing to regulate crypto, and winning this case could enable it to actualize further plans. Moreover, if the Commission succeeds in classifying XRP as a security, many other assets and some aspects of crypto operations will fall under its jurisdictional power. Moreover, if the SEC wins, the U.S. Senators Cynthia Lummis and Kirsten Gillibrand proposed legislation in June 2022 may also push through. Such a law may empower the Commodity Futures Trading Commission (CFTC) to handle crypto derivatives and trading. Johnny Deaton's recent post highlighted several compelling reasons why the outcome of this case could be particularly significant. In his view, very few court rulings have the potential to impact not just the US, but the entire world, and international holders have been left in limbo. 99.9% of all court rulings don't have the importance and significance this decision may prove to have. Not very often does a judge's decision impact not only the US, but the world. International holders have been left hostage, 17 amicus briefs at the district court level, etc. As per Deaton, 99.9% of all court rulings in the past don't have the same significance and importance. In his most recent statement, Deaton expressed his confidence that Judge Torres will say XRP secondary market transactions are not securities. What do you think will be Judge Annalisa Torres' verdict? Do you have a guess on when the verdict will be released? Make sure to subscribe to be updated on the developments of this case.